In April 2009, Vermont became the first state in the country to grant marriage-like rights to same-sex couples. I was in Vermont through the time that the grassroots effort to achieve this particular result was going on. I watched it happening in the towns and cities where I lived and worked. And I consider this a great example of the power of storytelling in advocacy and the power of grassroots advocacy work. So, I'm trying to tell some of that story. My sabbatical project attempts to gather the stories and collect them in one place for people to be able to listen and watch. When the effort started in Vermont, the state was already a place where sexual orientation was fairly well protected. It was included in protective statutes, including the hate crimes designation, and in 1992, the legislature actually incorporated sexual orientation into any legislation that was protective regarding discrimination. In addition, Madeleine Kunin, the governor at the time, named 2 liaisons from the gay and lesbian community to her advisory council. And as a result of this, much of the protective legislation went through fairly easily. Discussions began in Vermont with the Vermont Coalition for Gay and Lesbians, which actually was originally a support or a social group. Soon they began working with GLAAD, which is the Gay and Lesbian Advocates and Defenders, based in Boston. And throughout some of these videos, you'll hear reference to a woman named Mary. Mary was the executive director of GLAAD, and she worked very closely with the folks in Vermont. Together, these organizations created materials to teach the community how to effectively tell their stories. Beth Robinson was one of the founders of the Vermont Freedom to Marry Coalition. She was also lead counsel in the case of Baker versus the state of Vermont. Beth is now an associate justice on the Vermont Supreme Court, and she was willing to sit down and talk with me for several hours. Here's her story of how things got started in Vermont.
You know, there was a confluence of things that started the process. One thing that started the process was what happened in Hawaii, with the Hawaii Supreme Court really, for the first time, taking very seriously a claim for equal marriage rights for same-sex couples. I and my law partner, we were in a larger firm, but one of my law partners, Susan Murray, began talking about that as a possibility in Vermont. The second thing that happened is both Susan and I in our law practices were seeing case after case in which Vermonters faced real personal challenges to their families, and we didn't have the legal tools to help protect them because the law didn't see a family where one existed. And then the third thing that happened is a particular couple came to Susan. They had actually gotten a marriage license. It was a same-sex couple, and a town clerk had issued them a marriage license, but they called them afterwards and said, oh, I actually need you to bring that back. And they wanted to pursue this in court. And this was in 1994. And Susan and I talked, and I think we're both persuaded that the legal rights were there, but that this was a much bigger issue than just a court case. And so rather than taking the case, we decided that we wanted to commit ourselves to organizing to lay the groundwork in Vermont through public education and grassroots organizing, so that when we did take a case, and I think we fully intended to take one at some point, it was a more hospitable environment for the case, and the likelihood that that a successful case would be met with a successful counter move in the form of a constitutional amendment or legislation of some sort. We wanted to minimize that chance. The one other factor that played into this is that, for reasons that I can't fully explain, The Vermont LGBTQ community evolved dramatically during the time period from 1993 to 1996, and we actually there was an annual gathering of the community with various seminars through that period every year. It was called the Queer Town Meeting, and it was sponsored by Vermont Coalition for Lesbian and Gay Rights. And there was a session on marriage rights for same-sex couples in each of the years, 93, 94, and 95. And in 93, the overwhelming sense in the room was, this isn't really a battle worth fighting. In 1994, there just weren't that many people who turned out. There wasn't a strong sense that it was a battle worth fighting, although there was some sense it's a battle that's coming, whether or not we choose it. But in 1995, the room was packed, and nobody wanted to have the debate about whether it was a good idea because everyone realized the train was rolling down the tracks. And right there, that energy in that room is what we tapped for the first organizational meeting of the Vermont Freedom to Marry Task Force. So.
Virginia Renfrew was a student of mine at the time, and she was at one of the early meetings of the Vermont Freedom to Marry Task Force. Her firm was later hired to lobby in the Vermont legislature on behalf of the Vermont Freedom to Marry Task Force. But here she describes what it was like being at one of those early meetings.
There used to be an organization called the Vermont Coalition for Lesbian and Gay Rights, and every year they held a conference. And so it was the first time I'd ever gone to the conference, and Beth Robinson and Susan Murray were holding a workshop on marriage, and I went only because I just thought it was really odd to be talking about marriage at a gay and lesbian conference. And so I attended that and left there just thinking, like, I've never even thought that this would be an option. And so they were asking people to join the Vermont Freedom to Marry Task Force, and so I joined and started attending meetings. And at first we were a small group up in Burlington. At that time I lived in Waitsfield, Vermont. And so I would, go up to Burlington to these meetings. And
Eventually, it became time to start the legal action. So I asked Beth what it was that let them know that it was the right time. This is her response.
Yeah, I mean, again, these things are always, it's not one thing. So it was a convergence of things. And so within Vermont, first of all, we've been up and running for a couple of years at that point with Vermont Freedom to Marry. And I think we'd realized that we had gone as far, we were hitting a point of diminishing returns because the public interest in the issue was pretty low because it didn't seem particularly relevant. It's hard to get a Rotary Club to invite you to come speak about a topic that seems so completely hypothetical and off the radar screen. And so one factor was that we felt like we needed the litigation to create the opportunity to take the conversation to the next level. The second thing was we felt ready. We felt that we had done the grassroots organizing. We had actually talked to enough legislators that we had the commitments to avoid a constitutional amendment in response to a favorable decision. Now, obviously, that would be fluid because there would be a couple of election cycles probably for a decision, but we felt confident that we had a strong enough margin that even with some attrition, we weren't as vulnerable to what we saw in Hawaii, what we later saw. And then the third thing was that as we were getting, the other third local thing was that I think the confluence of the election cycle, the constitutional amendment cycle, which in Vermont, there's only certain years you can amend the Constitution, the rotation of judges, the turnover in the composition of the Supreme Court. There was a period in early 97 when things were up in the air because there were some vacancies that were getting filled. We didn't want to launch a lawsuit with that uncertainty. There was also some turnover in the AG's office. So it were very nuts and bolts things. And then the final thing was at the same time as we were having these conversations in Vermont, there was a national conversation amongst folks in the round table, the sort of leading thinkers in the movement, in the legal advocacy movement and the political advocacy movement, were regularly talking about these issues. And for a long time, the collective thinking had been, nobody should do anything until Hawaii runs its course. At that point, the Hawaii case had been on remand. The Supreme Court had ruled tentatively favorably, but there needed to be a trial on the question whether the state had a compelling interest. The lower court had ruled favorably, and then it had been sitting. And it had been sitting for a year and a half with no suggestion that the Supreme Court was preparing to act. And while that was happening, there was a tremendous amount of grassroots organizing against the freedom to marry for same-sex couples. So Hawaii was beginning to look like less clearly, it was becoming less clear that Hawaii was going to get over the finish line.
Okay.
And there was increased receptiveness to a second front, to sort of starting the conversation in another state. We never felt we needed anybody's permission to go forward, but we also didn't want to be those stupid fools who jumped into something ill-advised when all the folks from a national perspective were saying that's the stupidest thing in the world. And fortunately, they kind of came to the view that it was time and that Vermont was a good place. And Mary Bonato had a lot to do with that. And about the same time that we came to the conclusion that it was time to move forward.